Professor Thomas G. West is professor of politics at the University of Dallas, where he has taught since 1974. He is also a senior fellow at the Claremont Institute. He received his BA at Cornell University and his PhD from Claremont Graduate University. He served in Vietnam as a lieutenant in the U.S. Army. He has written a number of books and articles. One of his best known is Vindicating the Founders, published in 1997, which talks a little bit about some of the things that he's going to speak with us today. He's published also on various topics and translated various texts, and is very widely educated in political issues and political philosophy. Professor West.
Thank you very much, Richard. My topic is the universal principles of the American founding. What is the soul of the founding? Is it the universal political principles stated in the Declaration of Independence? Is it something distinctive about a particular time and place, such as Protestantism, the English legal tradition, the Anglo-American racial stock, or the U.S. Constitution? Or is it an amalgam of some or all of the above? Conservatives often say that the soul of the founding is located not in universal principles, but in something specific, either to colonial America or to the Constitution and laws created in the founding. Accordingly, one of Harvey Mansfield's books is called America's Constitutional Soul, not America's Natural Rights Soul. Conservatives tend to be uncomfortable with the language of equality and liberty found in the founding documents, which they sometimes disparage as, quote, rights talk, unquote. James Caesar explains in this way, quote, the right has always seen America through the prism of the French Revolution. For conservatives, the French Revolution was the result of a dangerous mode of metaphysical reasoning that wrongly tried to understand political phenomena from the perspective of abstract and universal principles, unquote. Conservatives associate those principles with the transformation that has taken place in America over the past century, a transformation that they deplore. As for liberals, they tend to argue, as Roger Smith does in his book Civic Ideals, that although the founders said they were adopting principles that apply to all human beings, they actually installed a political order dominated by racism, sexism, and homophobia. I will comment on slavery in a moment, but regarding women and homosexuality, the founders thought that discouraging sex outside of marriage and putting limits on female voting rights, although I have to say women did have the right to vote in New Jersey from 1776 to 1807, that these policies, founders thought these policies were consistent with their universal principles. Whether they were correct or not about that claim is a big question. As I argued in Vindicating the Founders, they made persuasive arguments that these policies promote family integrity while preserving the principle of government by consent, both of which they regarded as essential to the preservation of a free society. But the real liberal objection to the founding is not so much that the founders failed to live up to their principles, but that they had the wrong principles. The founders' understanding of liberty and equality was too narrow from the point of view of today's liberalism. After all, the founders' conception does not include the right to government-funded health care, the right to a comfortable home and food paid for by government, or the right to sexual self-expression. Against Mansfield, I will argue that the universal principles of the founding were its true core, and against Smith, I will argue that the founders' conception of their principles was both consistent and intelligible. But I hasten to add this qualification. Although universal principles guided the work of the founding generation, they were unable to create a government fully in accord with those principles. The most obvious example, of course, is slavery. The nation dedicated to the proposition that all men are created equal, as Lincoln claimed, only partly lived up to that standard. But as Leo Strauss writes, quote, "Every human being and every society is what it is by virtue of the highest to which it looks up," unquote. If that is true, then one may say that America, in its original incarnation, is defined by its principles. Every leading founder condemned slavery. Jefferson's words, justly famous, are, quote, "I tremble for my country when I reflect that God is just, that his justice cannot sleep forever." Many of the founders successfully promoted policies that limited the expansion of slavery, and in 8 of the early states ended it. What then are the founding principles? The question might seem to have an easy answer because famous phrases of the Declaration of Independence are so familiar. Created equal, life, liberty, and the pursuit of happiness, consent of the governed. But in fact, few Americans today have access to the reasoning that led the founders from these abstract principles to the laws and public policies that were crucial to the success of constitutional democracy. Many of the relevant documents and laws are hardly known today, except to academic specialists, although they are very easily accessible on the internet and very readable. One reason for that misunderstanding of the principles that prevails now is that the terms of the Declaration of Independence, especially the ideas of liberty and equality, have been verbally embraced, but in fact completely repudiated and redefined by the liberalism of the 20th and 21st centuries. As I mentioned earlier, the idea of equality is often taken to mean today that everyone should have the same resources as everyone else. The liberal view of rights is different from the founders, of course, for whom the right to liberty was a right to be free from the coercive interference of other people. They did not think it included a right to demand money and services from others, except in the case of a real inability to provide for oneself. They did have substantial policies to provide for the needs of the poor in cases of where they simply could not provide for themselves. There's a second reason why the Declaration of Independence and its principles is often misunderstood now. Scholars who work on the founding often focus on private documents, letters, personal statements, books, sermons, newspaper articles, which may or may not reflect the founders' consensus on principles of government. For example, in historian Gordon Wood's acclaimed 653-page book, The Creation of the American Republic, there is not a single discussion of the natural rights theory of the Declaration of Independence or of any of the other important official documents of the founding. Barry Shane similarly attempts to prove that the founding was not animated by a concern for individual rights, but rather by, quote, a Protestant communal understanding of the good, unquote. But in order to reach that conclusion, he has to exclude or distort the statements of principle found again and again in the leading public documents. A related obstacle to understanding is that scholars often look to individual founders to understand the theory of the founding. But Jefferson or Hamilton or Adams was only one among many. Focusing on individual founders typically leads scholars to highlight things that they quarreled about, like Jefferson's preference for farmers versus Hamilton's for manufacturers and financial magnates, as opposed to the bedrock principles that they all agreed on. One of the most striking things about the leading men of the founding generation is how different they all were in their particular preoccupations, and yet at the same time how much they agreed as a group on these basic principles. There's a third obstacle to an adequate understanding, which is that people are often tempted to consult European philosophers to explain the founding. So if there's an ambiguity or a question about the meaning of a phrase like consent of the governed, scholars will sometimes turn to a philosopher like John Locke and see what he says about it. I have no objection to reading Locke as a source of the founders' ideas. They quoted the founders, the colonists quoted Locke more often than any other political writer during that fertile period from 1760 to 1776, when they were explaining to each other the fundamental principles of government. But to get the most accurate picture of what they were collectively doing, it is safest to start with the official documents published by legislatures, conventions, town meetings, and other elected bodies, and of course supplemented by statements of prominent public officials acting in their official capacity, and of course the official documents are sometimes helpfully illuminated by private letters, sermons, and essays. But I don't think it's the right thing to do to start there. The Declaration of Independence is the best place to begin among the formal documents, because it is literally the founding document of the American political order. It was formally approved by Congress as the definitive explanation and justification of the Revolution at the moment when the United States became an independent nation. But the problem with the Declaration of Independence is it is so brief that it is sometimes difficult to tell what the key terms mean. The most notorious example is all men are created equal. However, it is actually pretty easy to clarify what the Declaration is saying, to fill out the picture of what it's getting at, by consulting other official founding era documents, which is what I'll do here. The second paragraph of the Declaration begins with the statement, all men are created equal. In what sense? One common error can be quickly disposed of. The word men in this statement, as in all leading statements in the founding era, refers to all human beings, not just males. One can see this in other pronouncements of Congress from the same period in which parallel phrases were used, such as rights of humanity, rights of mankind, inhabitants, obviously including both sexes. Second, to clarify the meaning of equality in the Declaration, the state bills of rights are especially helpful. In several of these bills of rights, the equality idea is restated always in slightly different words. Virginia says, all men are by nature equally free and independent. Massachusetts, all men are born free and equal. So what this suggests is that born free and equal and by nature equally free and independent are two variant expressions of the same idea, created equal. Four other early state constitutions used the same language. What is meant, therefore, by this statement of human equality is a fact, namely that no adult human being, that adult human beings are equal in the sense that they are not naturally subordinated to one another. They are equally free, meaning they are independent of all authority or rule by other human beings. This equal freedom is something that exists, quote, by nature, in Virginia's words. Equality in this sense, therefore, is not a product of law or social construction or government policy, as it is often said to be today. It is something that every human being is born with or possesses by nature. It is true that other human beings can take that natural equality away by force. And we can voluntarily agree to be ruled by others, in which case also we become unequal. Children are, of course, ruled by their parents without their consent. But once they reach the age of reason, they are free from all rule from others until force or consent changes that. And that, at least, was the view of the founders. And that is because no one is born to become a slave to another person, certainly including his parents, when he becomes an adult. Equality doesn't mean anything more than that. It certainly does not mean that we are the same in our intelligence, beauty, capacity for virtue, or wealth, or that all human beings have a right to possess equal amounts of property, or, for that matter, a right to be happy. There's a right to pursue happiness. It means that by nature, no one is the ruler of any other person. That brings us to the subject of natural rights and natural law. After all men are created equal, the Declaration goes on to say that human beings are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness. The fact that rights are listed after equality seems to imply that we're talking about two separate topics, equality and rights. In a sense, that is true. Equality is a fact of the human condition. No one is born the ruler of another. But rights are claims about how things should be, and not only how things are. I have a right to liberty, meaning if you try to make me a slave, you're doing something wrong. But a little reflection shows that the concept of inalienable rights or natural rights is nothing more than a different formulation of the equality idea, but this time with the juridical implications, the moral implications, made explicit. If everyone is born free, no one has the right to take that freedom away. This means that everyone has a right to life, liberty, and the pursuit of happiness. It means that each individual ought to be left alone to do what he thinks is necessary and appropriate to preserve his life. He should have the liberty to do as he pleases, including the right to pursue happiness in the way that he thinks best. So this statement of rights, inalienable rights, is at base nothing more than a restatement of the idea that we are born free and independent of the control of others, and that we deserve to retain that freedom and independence if we choose. If someone was born our natural ruler, we would not have the right to liberty. Though the one who rules us could rightfully deprive us of liberty and take away our life and property whenever he thinks that that would be best for us. In the state bills of rights, we find beyond these rights just mentioned other natural rights. Two of them are far more important than the rest and deserve to be noted here. One is the right to acquire and keep property. It is important to note the twofold character of the property right as it's stated in these state bills of rights. By protecting not only the right to possess, but also the right to acquire, the right is meant to benefit the poor no less than the wealthy. A just economic order, therefore, will enable the poor to acquire property by keeping the fruits of their labor or by selling their labor on the open market. The other fundamental human right is the free exercise of religion, sometimes called the right of conscience in the founding era. These five basic rights, life, liberty, pursuit of happiness, acquiring and possessing property, and free exercise of religion, are the ones named most frequently in the founding era. These rights sum up what it is that human beings have by nature, that is, what they are rightfully able to claim for themselves just by virtue of being a human being. And as I say, these rights also clearly imply duties. If you and I have a right to liberty, we have a duty not to make each other a slave. Property rights mean stealing is forbidden. If we have a right to life, we have an obligation not to murder. The founders sometimes formulated their idea of rights, therefore, in the language of duty. This is one meaning of the expression, laws of nature. In the first sentence of the Declaration of Independence, the laws of nature and of nature's God entitle every nation to a separate and equal station among the powers of the earth. The laws of nature justify the idea of national independence and forbid the imperialistic domination of one nation over another nation. That first sentence of the Declaration does not say why this is the case, but it is easy to see that it is directly related to the statement in the next sentence that all men are created equal, that they have the same right to liberty. Because if we are all free, no nation is allowed to rule any other nation for the same reason that no individual is allowed to rule any other individual without that person's consent. All relations among nations, therefore, just as among individuals, should be based upon voluntary agreements, not coercion. And this, by the way, is the basis of the founders' understanding of foreign policy. There's no place in their understanding for nation building as a mission of the United States government. The laws of nature, then, are nothing more than the duties that follow from the rights of individuals. Or perhaps it is better to say, as the founders most often said, that the rights of individuals are founded in the laws of nature.
the basic obligation to obey, to respect everyone else's liberty is the ground of the right of each person to be free of the coercion of other people. A typical founding era statement of the relationship between the laws of nature and the rights of the individual is in Congress's 1774 Declarations and Resolves, which says, quote, "By the immutable laws of nature, the colonists are entitled to life, liberty, and property, and to participate in their legislative council," unquote. When today's scholars discuss these natural rights, they often leave the impression that the founders had only a vague idea of what they meant. Jack Rakov, a prominent historian, writes, quote, "But the frequency and enthusiasm with which they celebrated their rights and liberties also gave those terms a flabby imprecision," unquote. But in the founders' understanding, their meaning is quite clear. When human beings live together under the laws of nature, respecting each other's natural rights, no one suffers violence to life or limb except as a just punishment for violating the rights of others. Everyone is free to live in the way that he or she wishes. All may worship God as they think best without interference. Each person may use his talents to acquire property through voluntary transactions and to be assured that that property will be safe from the depredations of other people. Families are to be free from the micromanagement of outsiders. All dealings among adult human beings are based on personal choice, or in the case of group activities, on freedom of association and voluntary contracts. Everyone is free to join any association he pleases if the members of that association will have him. The association has a right to expel anyone for any reason, just as any member of that association has the right to expel the association, that is, to quit and no longer to be a member. And that is true whether that association is a church, club, private school, philanthropic group, or place of employment. In the founders' vision of the good society, peace, harmony, friendship, love, and happiness will flourish on the basis of self-governing political communities, self-governing private associations, and intact families. In sum, to quote George Washington's letter to the Hebrew congregation in Newport, "Everyone shall sit in safety under his own vine and fig tree, and there shall be none to make him afraid," quoting the book of Micah. All these things were supposed to take place within the confines of rules that will limit one's liberty, but only to the extent that those limits enhance the enjoyment of liberty for everyone. We give up, for example, the right to punish crimes, which we would have if we did not live in a political society, for the sake of everyone's mutual security being better protected. This brings me to the role of government. What then is its job? Some scholars argue the founders' principles provide little or no guidance for the conduct of political life. Barry Shane writes, quote, "Natural law and rights described a condition outside of civil society, and this meant for most of them that such claims played a limited role in shaping the specific moral and political contours within society," unquote. Pauline Maier, author of a famous book on the Declaration of Independence, argues that the Declaration was, quote, "a peculiar document to be cited by those such as Abraham Lincoln, who championed the cause of equality for slaves," unquote. And then quoting Maier again, "Not only did the Declaration's reference to men's equal creation concern people in a state of nature before government, but the document's original function was to end the previous regime, not to lay down principles to guide and limit its successor," unquote. Shane and Maier seem to be saying that the founders' equality doctrine means that human beings possessed equal rights only outside of civil society, so that once they become members of a society, their original equality has little or no further significance. The Declaration of Independence itself contradicts these scholars. Government's main purpose, it says, is to secure these rights. Most of the state constitutions echo this, For example, Pennsylvania, 1776, says, quote, all government ought to be instituted for the security of the community and to enable the individuals who compose it to enjoy their natural rights. To secure these rights means to protect people's life, liberty, and property against violence. This leads directly to specific moral and political contours within society. I give 3 examples. One obvious means by which government secures our rights is the criminal law, which in the Massachusetts Bill of Rights is specified as the means by which government protects life, liberty, and property. Jefferson explains, quote, wicked and dissolute men commit violations on the lives, liberties, and property of others. Government would be defective in its principal purpose were it not to restrain such criminal acts by inflicting due punishments on those who perpetrate them, unquote. Another way that government protects the citizen's person and property is by its armed forces, deterring or defeating violence against the community from abroad. Finally, government cannot secure the rights of the individual without a necessary moral foundation. And for that reason, several of the state bills of rights, including Virginia, 1776, states, quote, no free government can be preserved but by a firm adherence to justice, moderation, temperance, frugality, and virtue, unquote. This or similar language was repeated in the constitutions of 4 other states, as well as the federal Northwest Ordinance. This concern led to government support of religion, education, and lasting marriage. Besides the primary duty of government to protect natural rights, a second conclusion follows from the equality principle, and that is that governments, quote, derive their just powers from the consent of the governed, unquote. 13 of the first 16 state constitutions affirm the people's right to political authority as fundamental. The most succinct of these is Maryland, quote, all government of right originates from the people, but the other constitutions were similar. The practical meaning of the consent principle is no authority of one adult over another is rightful unless voluntarily agreed to by the person being ruled. This implies a form of government that is not only consented to at the moment one joins the community, but also has a substantial democratic element in the lawmaking body, so that the people can determine the broad direction of government policy after they become citizens. At this point, I turn to a view that prevails among recent scholars, namely the claim that the founding is a kind of blend or amalgam of disparate elements. Alexis de Tocqueville, writing in 1835, may have been the first to assert that there is no logical connection between the founders' concern with liberty and their concern with morality. Tocqueville writes, quote, Anglo-American civilization is the product of 2 perfectly distinct elements. I mean to speak of the spirit of religion and the spirit of freedom. Thus, in the moral world, animated by the spirit of religion, everything is classified, coordinated, foreseen, decided in advance. In the political world, still quoting, where the spirit of freedom prevails, everything is agitated, contested, and uncertain. When Tocqueville says that the spirit of religion and the spirit of freedom are perfectly distinct, he anticipates the current view of the individual rights doctrine. The recent literature tends to treat the political theory of the founding as an amalgam of distinct or even contradictory traditions. For Michael Sandel, the traditions are liberalism and republicanism. Sandel argues that liberalism is a tradition running from John Locke, Kant, John Stuart Mill to John Rawls. Liberal thinkers, Sandel says, believe that government should be neutral on the question of the good life. But Sandel rejects liberalism on this ground, quote, if government is neutral on moral and religious questions, it cannot secure the liberty it promises because it cannot sustain the kind of political community and civic engagement that liberty requires, unquote. Sandel thinks that the founding was based partly on this liberal neutrality, but that it was combined with a countervailing and more powerful doctrine of republicanism. The Republican concept of freedom, writes Sandel, unlike the liberal conception, requires a formative politics, a politics that cultivates in citizens the qualities of character that self-government requires. William Galston agrees with Sandel that the origin of today's problems lies partly in what he too calls the liberalism of the founding principles. Galston writes, the founding set in motion a new political order based to an unprecedented extent on individual rights, personal choice, and democratic, egalitarian social relations. What happened to the American family in the past 2 generations is in important respects a consequence of the unfolding logic of authoritative, deeply American moral political principles, unquote. For Galston, like Sandel, the unfolding logic of natural rights was restrained by a long-standing balance between juridical liberal principles and a complex of traditional moral beliefs. An amalgam of the essentially secular principles of democratic liberalism, the moral maxims derived from Christianity, and the moral habits of Protestant Americans. This is Galston's summary. Galston's approach is superior to that of most scholars because he knows that Locke and the founders held that a moral foundation is necessary for security of rights. However, Galston believes that in spite of that commitment, the founders' acceptance of these, what he calls juridical liberal principles, proved destructive of their own moral basis. The question is whether Galston is correct when he blames the founders' principles for those features of contemporary liberalism to which he objects. I would argue that the post-1900 transformation in the American understanding of justice is better explained by the rejection of the founding principles by leading intellectuals after the Civil War and not by what Galston calls their unfolding logic. Political theorists are only gradually beginning to absorb the implications of recent research on progressivism and its legacy, which explicitly, I should say, the progressives explicitly and repeatedly repudiated the natural rights doctrine and natural law as unjust, ignoble, and untrue. The scholarly term liberalism is itself a sign of the problem. The founders called themselves liberal, to be sure, meaning generous or respectful of the rights of others. They were devoted to liberty. They respected the virtue of liberality, generosity. But they were emphatically not liberals in the sense in which that term is used when it is applied to Franklin Roosevelt, Lyndon Johnson, or Barack Obama. The scholars' casual use of this term, liberalism, for all of these categories, for all these individuals, is evidence of their underestimation, I would say, of the radicalism of the progressive and post-1900 liberal revolution in American politics. But let's consider a little more closely the question of this amalgam thesis. In the case of tooth fillings, an amalgam is a mixture of several metals in which the distinctiveness of each metal is lost and absorbed into the whole. The scholar's use of that term therefore suggests a kind of indiscriminate blending of the different aspects of the political traditions inherited in the founding. English constitutionalism, Protestantism, republicanism, and natural rights. Sandel says that a large dose of republicanism, orientation towards community and the common good, was able to dilute a smaller dose of liberalism, orientation towards self-interested natural rights, in such a way that the liberal selfish dimension was overwhelmed by the public-spirited Republican one. That's Sandel's view. Against Sandel, I agree with those scholars who argue that the philosophy of natural law and natural rights in the founding was its core. I agree with Galston in particular that from that idea, applied to the particular circumstances of the English colonies of North America, the founders drew their conclusions about government structure, promotion of Christianity, and formation of character. But this means that the founders' acceptance of the legacies of their colonial experience, such as the English common law, periodically elected bicameral legislatures and all the rest, was dictated by their judgment of which elements would most effectively secure the natural rights of the citizens. I suggest that a horse and rider is a better analogy than amalgam for the bundle of ideas and institutions that constitute the founding. The rider is the politician, informed by the natural law philosophy. The horse is whatever materials the statesman has to work with, including the existing legal and religious traditions, racial stock, geography, popular sentiments, and moral habits. The horse is not something the statesman can invent out of nothing. It can be guided in the right direction if he is a skillful rider, but he has to work with the laws, religion, customs, and other traditions, the horse that he's given. If the horse is too lame, stupid, or resistant to guidance, the rider might not be able to get very far. There are limits to what any statesman, however prudent, can do with the people and the traditions that he inherits. In most of the world today, it would be difficult or impossible to establish a political regime that successfully protects the natural rights of the individual on the basis of the consent of the governed. But in the founding, the horse happened to be unusually healthy, already habituated to going more or less in the right direction, and eager to accept the rider's direction. The founders inherited a colonial tradition of English law, Protestant Christianity, and Republican political institutions that was warmly supported by the people. Educated preachers and politicians had long come to accept the modern natural rights teaching that then became the official basis of the founding. What marred the colonial state of things from the point of view of the teaching that became that basis of the founding was the persistence of certain British traditions that were opposed either to government by consent or to security of individual rights. Most of the colonial governors were appointed by the king, and royal vetoes of colonial laws were common. Two elements of the English tradition that the founders' principles rejected. The American Revolution could never have succeeded to the extent it did without something like the accidentally pre-existing colonial religious and legal traditions, the healthy and intelligent horse. But the revolution would not have taken the direction it did without the leading role of the natural rights theory. To clarify my horse and rider analogy, I turn to legal historian John Reed. He admits that a multitude of documents in the pre-1776 period appeal to natural law and individual rights, but Reed denies their significance. He argues for what he calls the irrelevancy of natural rights. He claims that nature was mentioned either as alternative authority or as rhetorical flourish during the 1760s and 70s, but that the real source of rights, actual legal rights, was British constitutional theory or common law. To illustrate, Reed quotes Congress's 1774 Declaration and Resolves, which relies on, quote, the immutable laws of nature, the principles of the English Constitution, and the several colonial charters. In that document, Reed writes, not one right is asserted that was not either a constitutional right or a right derived from the authority of custom or law. I agree with Reed on the importance of that 1774 Congressional Declaration. He's also correct that prior to 76, the Americans were careful to appeal to both natural law and English tradition, but they had good reason to do so. The American strategy was to argue that the colonial governments were grounded in both natural and positive law, meaning the immutable laws of nature on the one hand and the principles of the English Constitution on the other. The American view was, as long as England was willing to respect its own constitutional tradition, the colonies would gladly continue as 13 self-governing political communities within the British Empire. But the moment that England repudiated this American understanding of the English Constitution, the appeal had to be to natural law alone. Because if Parliament changed the English Constitution, for example, by abolishing the right of colonial self-government, any further appeal to the English Constitution would be in vain. In the 1760s and 70s, the American idea of the English Constitution was basically that body of English law that conformed to the principles of natural law. In other words, far from being irrelevant, as Reed argues, the natural rights theory determined for the Americans the very meaning of the English Constitution. An illustration of this is one of the American pamphlets discussing voting rights in England. The pamphlet noted that 9/10 of the people of Britain are not eligible to vote because voters had to own so much land in order to have that right. And the author of the pamphlet concludes that the structure of Parliament itself is contrary to the fundamental principles of the English Constitution. Thus, the English Constitution did not even fully exist in England. Instead, in the American mind, it became a kind of higher law standard that could be appealed to without apparent or obvious disloyalty, as long as the Americans remained part of the British Empire. After 1776, the American position towards that English tradition became even more explicit. New York Constitution, for example, states that the common law of England will be in force except for such parts of the common law that are repugnant to this Constitution. Which parts are repugnant? The answer, of course, is those that conflict with the principles of government stated in the preamble to the New York Constitution, which quoted the entire Declaration of Independence as its preamble. Like all the state constitutions of the founding, New York's was intended, in other words, to secure these rights. Therefore, what I'm suggesting is that there's no indiscriminate blending or amalgam going on in the founding. The authority of the common law was strictly limited by an appeal to the standard of natural law. Natural rights were in the saddle. What does this mean for us today? It enables us to understand why the founders' principles may be indispensable for us. For if they really are true of all human beings, if the founders' ideal society is one that is a good society, if the principles do provide for robust support for the moral and religious conditions of orderly freedom, then we will be able to explain to ourselves better, as well as to others, what many of us believe without always being able to say why. Namely, that the Constitution, grounded as it is in the founders' natural rights theory, is good, and that it is worth returning to as a guide to our political life. Thank you.